Okay, ma'am. We will start the session now. Good evening, audience. Welcome to another enlightening session organized by Just Corpus. I'm your host, Aksharaditya, and I'm absolutely thrilled to be here with you. Before we begin, let me introduce you to our esteemed guest speaker, Dr. Shivangi Sinha, ma'am. Ma'am has done her graduation from KIT Law School, KIT University, Bhubaneswar, Odisha, and completed her post-graduation from the National University of Study and Research in Law, Ranchi. She did her PhD in arbitration and corporate law from Bharatiya Vidyapeeth New Law College, Pune. She has experience of 1 year in the field of litigation in matters related to civil, criminal, and all types of writs, contract drafting, negotiating terms, and vetting documents. She practiced at Jharkhand High Court and enrolled as an advocate under the Advocates Act 1961. He has also worked as a legal expert at LEDX and is also a subject matter expert at TCS-IM. He is presently working as an assistant professor and faculty coordinator of the ADR cell Madhyastha and the incubation cell and placement cell at Bharatiya Vidyapeeth, New Law College, Pune. He is also a member of the Young Mumbai Center and International Arbitrations and a member of the Chartered Institute of Arbitrators. Her expertise lies in the fields of corporate law and business law, alternative dispute resolution, cyber law, legal research, and legal rights. She has various publications in the subject matters related to ADR, corporate laws, cyber law, and insolvency, etc. in numerous national and international journals, UGC journals, Scopus Index, etc. To our esteemed guest, thank you for joining us. We are honored to have you here with us tonight. Now, before we dive into our topic, let me give our viewers a brief overview of the organizer behind tonight's session. Just Corpus is a body of legal professionals who have brought various aspects and chains of law under a single umbrella. Just Corpus, an EdTech platform established in 2020, has a wide reach of 600K clicks per month on an average basis on its website. This inspiration was derived from the ever-growing need of law students. Just Corpus is also incorporated an interdisciplinary journal as a subsidiary named the Just Corpus. Now on to the main event. This evening, our esteemed guest will be shedding light on the topic of evolution of ADR. Now, the virtual stage is yours.
Thank you so much. Good evening to one and all present here. My name is Dr. Shivangi Sinha, and I work as an assistant professor at Bharatiya Vidyapeeth Deemed to be University, New Law College, Pune. Before I start with the session and enumerate my thoughts process about this topic, I would first like to thank Just Corpus for approaching me for this guest lecture. And many thanks to the coordinator for organizing this event. Many thanks to Aditya for such a warm introduction. Thank you so much. So today here we are to discuss a topic naming the evolution of ADR, that is the alternative dispute resolution in India. Now, whenever we hear this particular term, alternative dispute resolution in India, the first thing which comes to our mind is something which is very new. With a layman perspective, we can also consider it as an alternative to resolve disputes or conflicts from the traditional method without going into the traditional or the communal method which we use in our day-to-day life. That is going to the courts. That is the real sense which comes to our mind. However, when evidences are being procured and we see a lot of instances with respect to alternative dispute resolution, there is a lot more historical analysis, because today what we see and today what we say that, okay, litigation is something which is the adversarial approach, approached by everyone. Whenever we have any kind of dispute, we'll go to the court. And if we want to resolve our disputes out of the court, we'll opt for alternative dispute resolution, which is a very new concept for everyone. So I am here today to break this ice and say that no, alternative dispute resolution or even external dispute resolution, we can say for that matter, is actually a very old and a very, I would say, the new concept with the old book cover, what we can say today. Okay, it signifies various dispute resolution mechanism that we see today. And we have a lot of legislations which are supporting, though we considered alternative dispute resolution as the private process. It's a private process of dispute resolution, and that is the reason there are parties who are still apprehensive to offer this private process, and they say that, okay, if we have a dispute, why not to go to a structured form and resolve the dispute through litigation? But if we see, then ADR itself have a lot of mechanism. For instance, we have arbitration, we have mediation, we have conciliation, we have negotiation, lok adalat. In today's time, we'll see then we also have MIDA process, blockchain technology, the amendments and brought about fast track arbitration as well. So all these are the different parts of alternative dispute resolution which we are dealing. Now, when we talk about the historical perspective, I just want to prove here a particular point that what we see today, alternative dispute resolution, and what we say that it's a private process, I don't know, it's a very new thing. How should we go for it? No, it's not the scenario actually. This is something which we've been traveling and we've been following through the traditional approach. And today we have just given the form structured format. So what I'm going to do is that I'm going to deal with all the phases of ADR and how it was being used and how it was being stated by people at that point of time. Whether it is your, Indus Valley civilization, whether we speak about the different dynasties which we deal in, or whether we speak about, the Arabic times, everywhere we had arbitration, everywhere we had mediation, but now we just have new legislation to it. It is a much more structurized process. Therefore, we just kind of look into a very private and a new thing, which obviously people don't have faith to. Okay. Now, if we speak in a very, generic way, it is always considered wise enough to resolve any issues within the four walls of a room. Okay, to protect the dignity and to protect the stigma which can come out into the society. Now, this concept can relate us that how this dispute resolving mechanism is so much popular from the ancient times. And one of the earliest instances, when I want to start with the historical perspective, I would like to trace back to one of the earliest instances of the era of King Solomon, who once tried to settle the dispute between the rightful claim of a baby boy between two mothers, and that is who is the real mother of the child. Now, there are various historical references which proves that the concept of our out of court settlement mechanism was knowingly, unknowingly followed even before the Christ. Like, for example, I can give a very basic example. We call the process as arbitration, and the people who resolve the disputes, we call them arbitrator. If we go into the Arabic times, the same process of arbitration was known as takim. And the people, the arbitrators, who today we look as, the dignified appointed people through Arbitration and Conciliation Act of 1996, were known as hakim. So we can see that even at those point of times, they were just the synonym, the words were different, but the meaning remained the same. So even in the Arabic times, these were the people who used to listen to the disputes of the, the conflicting parties and try to resolve it into the four walls. Now, before going into the ancient time, into the ancient India, where I'm going to first start with the, Indus Valley civilization, one thing which I mentioned over here is about the stigma. So basically, the matters which are not of very serious nature goes to alternative dispute resolution. This is something which was also mentioned in the case of Booz Allen. So when we talk about serious matters, we basically say that, okay, whatever are the criminal offenses or anything of that sort where we need to have a penal provision, which is not there in our statutes, let's, resolve these matters through courts, which is completely justified. But when we are talking about the family disputes, whenever we are talking about the commercial dispute, these disputes still, want to go and get resolved through alternative dispute resolution. Why? Because we want to save time, we want to save money, and it is a confidential process where we save the goodwill. Okay, the company saves the goodwill. So if any of the conflict has been resolved within the four walls, the goodwill of the company is not getting tarnished. Okay, so that is the reason this was the most famous and the most important aspect, that it is not it is not publicized until and unless it is being required, until unless it is for public importance. So that is the reason these resolving disputes in the four wall is actually very important. And when we are talking about the ancient India, I actually want to, start from a particular concept where we have also seen, the people or the children who are reading their small books, where there are people who are sitting under the tree listening to other people and trying to resolve their disputes. Today in our Indian constitution, we recognize it as panchayats. So all these are the traces of the historical development of ADR. Today, now we see it in a structured format. Now, if I take you down to the ancient India part, okay, where I'm going to definitely use certain terms which is quite relevant with respect to ADR. Ancient India gave birth to the concept of mature civilization, which we cannot forget. Whenever we hear the term ancient India, the home of two most famous cities which directly come to our attention is Harappa and Mohenjo-daro. That was the first ever cities using the stone buildings, having multiple stories, etc., and many more things. Now, why am I taking you to these kind of mature civilization? Because even in ancient India, which included the king, the monarchs, the empires, the ruling of various dynasties, all these civilization existence of various dynasty practice various transactional and commercial practices. And they also have various dispute, various conflicts, because obviously when there are two heads which are coming together, that is the meaning of a company also, COMPANY. Okay, that means people are coming together to have their bread together and they discuss business. That is what even company is today. That is what it has been formed. So when there are so many people who are coming together who are trying to resolve the dispute, obviously there is room for conflicts, and they want to have a very peaceful settlement at even that point of time. Even during the monarchs, the empires, the Mohenjo-daros and Harappas, they used to have separate settlement for the same. Okay, even when we are talking about ancient India, we cannot forget the Vedic times. Okay, even the Upanishads, when we see the Vedic history, there also we have certain terms. Okay, we don't call that particular concept as arbitration as we call it today, but there were certain terms. Like for instance, they use the term pugas. Okay, they were the local courts which consist of people from different sections. Then there was Sarni, that was the community of the various tradesmen, businessmen who hails from different tribes, and they were connected to each other professionally. Then there was also a system called Kula. Okay, they were connected to each other by family ties. And these all bodies together at that point of time consist of a panchayat, and they comprises of arbitrators, the third party involving the dispute resolution, which today popularly we known as punch. Okay, the most I would say the paramount part of these body were that they were free from any kind of formalities, any kind of cumbersome, any kind of technicalities, which was the most important part. Even at that point of time, I remember there were various cases which has come across. There was a case in 1934, if I'm not wrong, it was a of Vatalya Sitana. That was a case which was being stated, and that time also the court stated that when the decisions are coming from these kind of bodies, the panchayats, the punts, and everything, they do have a binding effect. Okay, and there is a brief attached to the parties. There is a particular baggage which the parties have, that they have to follow the decision which has been given even by these private parties. However, at that time also, like today, when we are aggrieved from the judgment of the lower court, we go to high court and to the Supreme Court, to the hierarchy. Same thing, even that time, the aggrieved party can go against the decision to appeal to the different body. Like for instance, for Cerny, against decision can be go to Kula, from Kula to Puga, and finally they had some other legal advisors who used to take equal responsibility of to provide justice to the people. So my point of view over here is that even at that point of time, dot knows in not in a very structurized format, but they do have instances where there were arbitral bodies into existence. One more important thing during the ancient India was the concept of guilds. Okay, GUILDS. Okay, guilds were also very unique and very famous throughout. Guilds were considered as a group of people or any association of the tradesmen, artisans, etc. And they used to form, I would say, a multifaceted organization which not only worked for the government but was also for a court of justice of various technical institutions. Now, if any kind of judicial agreements of these states, this guilds encompass a very prominent position for the dispute settlement. And they also had provisions of various royal authorities. Okay, so in the ancient India, we can say that yes, of course, not directly, but yes, of course, we do had these kind of bodies which try to resolve the dispute under different names. They were heading under different names, but their motto and objective was the same. Okay, now arbitration was also a very well-known concept during the times of dynasties, such as we had Mauryan dynasty. During the period, king was considered as the head foundation of the legal system, prevailing the matters pertaining to grave consequences, and it was being decided by them. They were also they were also bodies which where arbitrations was being situated at local levels. Okay, and important cities have different headquarters which were hailing. We can also see the instances in Gupta dynasty in the during the northeastern India, which followed the mechanism of ADR. But the whole empire had various administration division, namely Rajya, Rashtriya, Desha. Okay, so these were the different heads which were being formulated under Gupta dynasty. And what was their work? Just to listen to the conflict at that point of time and get it resolved. I would say that the Gupta dynasty believed in sharing the power. Like today, we say that delegation of power under administrative law. So the Gupta dynasty believed in sharing the power rather than keeping it concentrated, and therefore numerous powers for the dispute settlements were being transferred to the village panchayats, to the town councils, and even the empire was also very famous for its distinct judicial system. Initially, the matter was taken to the lowest judicial setups, and if they were not able to get resolved or they were not able to reach to some amicable settlement, these matters were taken to the councils. Okay. Now, when we are talking about dynasties and when we are talking about rulers and everything, we just cannot forget the Mughals. Okay. So when we have to take the reference from Mughals, there was also a term called Hidayah. Okay, that contain various provisions of arbitration which we deal today. Now, when I started with the lecture, I mentioned about the Arabic terms. Okay, so in Arabic, hidayah basically means guidance. It is an author, or I would say it is an authoritative text of Islamic law, which was written during, I guess, the 12th century. And in Arabic, arbitration is known as taqim, while the arbitrators are known as hakam. And these hakams, the arbitrators, were supposed to have all the qualities of qazi, who can be considered as the official presiding officer, and the decisions which were given by them were again considered binding on the parties. They were the official presiding over the court proceedings, and during the time of Akbar, I would say the Brahmins were considered to resolve the matters of the Hindus. Villagers also used to resolve the case in the village court or appeal to the panchayat at that point of time. Even if we come to the Maratha times, okay, Maratha also emphasized on the amicable settlement of dispute. Even after the defeat of one party, they ensured that the good relations between them are maintained, and they do not carry any emotional baggage with them, or they do not carry any, I would say, issues related in future. In Maratha also, panchayats were the first instrument to, resolve any kind of dispute. The village had patils, the town had mahajans, okay, and the dispute resolution bodies were simple, and they were taking for very minute matters, for trifling matters. Okay, and panchayat had certain rules and regulations prescribed, and both the parties initially has to accept before the proceeding is initiated. Furthermore, we can also emphasize that panchayat study the matter thoroughly and then pass any judgment without any biasness. Just in case the party failed to resolve their dispute amicably, then they would go to the higher authorities. Okay, they used to approach the higher bodies. So with this ancient time, whatever, dynasties and everything which I have mentioned in a very brief manner, I just want to say that they just had one motto, that you want to resolve the disputes amicably. You, even after disputes have been taken into consideration, when you are going out from the room, you don't have to carry any emotional baggage. You have to maintain your relations properly, and then you have to take things forward rather than making things very complex, very time taking. Even they considered amicable settlement of dispute as one of the best resolution to run the society, which is what we are doing today in a much more structured form, but we consider it as a private process. Now, when we are touching about the evolution of ADR, and when we are talking about lot of dynasties and everything, we need to also focus from where actually ADR, the concept of ADR, got a structured format of the statutes. Okay, today when we see, we have Arbitration and Conciliation Act of 1996 till amended till 2021, which is dealing with arbitration and conciliation. We have the latest Mediation Act of 2023, which is dealing with the mediations. Conciliation, like I already told, has been covered under the Arbitration and Conciliation Act. Negotiation is now being considered and is being recognized by various arbitral institutions like SEAC, Hong Kong Arbitration, etc., etc. And of course, there are rules and regulations which are even coming for the latest developments under the concept of ADR. But from where have we actually got these statutes? So these genesis actually came from the British rule. So now after ancient India, I want to focus towards the British rule, that how the evolution of ADR in British rule was also helpful. After looking at these historical ambits of the discussion today, when we try to recapitulate the genesis of ADR mechanism, we find it in a more texturized format and at times considered as a new growing legislation, I would say. But actually, the ADR mechanism was initiated in a structurized format primarily due to the British period, like I told, which is popularly known as the East India Company or the British Raj. Now, British period lasted from 1858 until the independence of India and Pakistan in 1947. This mechanism actually gained popularity because of the trade factor, which we all are aware of in the history, which was highly valued by the emperor during the ancient times. And therefore, in case of any conflict which arise between them, the dispute which used to arise between them, the traders used to opt for out of court settlement for the quick redressal so that any obstacle occurring get resolved and they can carry out their trade activities peaceful. Like I already mentioned that they always wanted to have something very peaceful settlement, peacefully taking things forward. Now, when I'm talking about the texturized structure, so the question is that from where are these words, the verbatim which we read today, from where are they getting their genesis? So we can start it from the Bengal Resolution of 1773, which was formulated, which elevated the use of arbitration. It encouraged the parties to submit the matters for arbitration, and this act was amended again, I think, in the year 1780, then 1781 again, which again emphasized and designed encouraged arbitration. The parties under the act used to present their cases in front of the arbitrators, which was being chosen by them with mutual agreement, and the decision given by the arbitrators were binding on the party. Now, this is something which we follow today, and we call it as party autonomy, which is very famous. And that is also, I would say, one of the pro as well as con the term party autonomy, that why people today go for arbitration. Why? Because you have that particular own right where we can choose your arbitrator who is going to resolve their dispute. You can choose your own choice of law. You can have your own seat of arbitration. Okay, all these things are now more in a structured format, but we can see the emphasis even in the history. And basically, mutual agreement is very necessary when you are talking about ADR. Any of the parties in conflict need to have a mutual agreement, and then only they can go further. I would say the first Indian legislation, which was formulated in the year 1899, but its ruling was confined only to the presidency towns of that point of time. That was Calcutta, Bombay, and Madras. Although the Bombay Regulation Act of 1799 and even the Madras Regulation Act used to put the same effect in Bombay and Madras presidencies, but still, after its enactment, there were a lot of judicial criticism which came across. If we furthermore try to attract some more texturized format with respect to arbitration, what we see today, we can see that there were perspectives of international arbitration, because we are talking about trade, which was discovered even at the historical perspectives in the historical time only. How? There was Geneva Protocol on Arbitration, 1923. Then there was Geneva Convention on the Execution of Foreign Arbitral Award, 1927. Then there were arbitration protocol and convention. Okay, later on, when we were seeing that there were so many statutes which were running across, they actually made Indian Arbitration Act of 1899 as one of the first Indian legislation which was being formulated in the name of arbitration, which was being followed both by the Indians and the Britishers. Now, the most important thing over here which we need to understand is that today also we see amendments coming a lot, like for example, if we see any of the statute for that matter, just for example, if we see Arbitration and Conciliation Act 1996, even it was being built in 1996, we had seen amendments in 2015, we have seen amendments in 2019, we have seen the latest 2020 bill, and which was being passed, and now we have the Arbitration Amendment Act of 2021. Why this change and why this amendment is necessary? This is only important because we live in a society which keeps on changing, so there is always a growth which is attached. Now, when there is a growth which is coming across, we need to amend and change the law simultaneously at that point of time. The best example which I can give here is of cyber law. The laws in cyber keep on enhancing itself, just as the cyber crimes are happening. Or rather, even I can also use the example of security market. Security market is very volatile in nature. The SEBI keeps on updating their laws because we know that every time there is something or the new coming into the stock market or into the security market. So the same thing applies, the same concept applies even in arbitration. We know that there was a textured format. We know that there was a concept of amicable dispute resolution, and we want to take that particular concept forward. And therefore, we started making laws on that so that people start getting attracted towards it, because we see that, okay, if there is a legislation, we can definitely follow and people are going to trust it. So the first texturized format of, we can say, the people sitting under the tree resolving their dispute, the first textured format for that came in the year 1899. But now, like I said, amendments are very important because society keeps on changing. So this Indian Arbitration Act of 1899 was replaced by Arbitration Act of 1940. Now we start with a more textured format, the more legislative format of the evolution of ADR in India. There was a situation of pre-independence and origin of legislation, okay, in arbitration. And this was this particular period. Because as mentioned earlier, during the British origin, many legislations were formulated, enacted, which was brought, I would say, a drastic change in the administration of India. Till 1772, the courts, either by its own discretion or by the choice of the party, used to refer to the matters to the arbitration. After a decade, I will say, we also had the concept of civil procedure code, which was being developed in 1859 at that point of time, which enacted. They also recognized the concept of arbitration, which was formulated in their sections. Okay, but because of some evident loopholes, these sections were again replaced in the year 1882. Further, in the year 1899, the Indian Arbitration Act 1899, which was being enacted at that point of time based on the English legislation, the scope of this act was limited only to the presidency towns, like I mentioned before, Calcutta, Madras, and Bombay. Now, this application of this act was confined to the matters to the dispute which were not the subject matter of any suits. The statute also consists of a provision where it was very compulsory for the parties to state the name of the arbitrator who's going to resolve their matter, how you're going to judge that who is eligible to become the arbitrator. So there were a lot of loopholes which were coming when they were, addressing about the legislation. During that period, the court considered an arbitral award to be treated mere like a compromise between two parties. So even at that point of time, the court system, which was being established at that point of time, even they used to think that no, fine, it's okay. It's just like a compromise which is happening. They don't want to come into the court, so they're doing a kind of compromise. So that was I would say, the reputation at that point of time. Although because of too much of complexity, lengthy provisions, in the field of arbitration, and also with respect to the arbitration, there were a lot of cases also which came across, and there were a lot of cases which stated that Indian Arbitration Act was unnecessarily complex and the legislation should try and bring reforms in order to, restore back its relevancy. Okay, and what is the relevancy? We want to avoid the lengthy process of the court, and that is the reason we want to have out of court settlement. Even for the out of court settlement, if you are doing the same process, you're bringing the same complexities, then there is no point in opting for this alternative mechanism. So that is the point, that was a turning point where people actually recognized this and they thought that, okay, no, if you're thinking that arbitration should be an advantageous process for the people for the amicable settlement of dispute, whatever the motto they were carrying forward from during the ancient period of time, if we want to restore that, we need to work on their legislation as well. So again, in the year 1908, Civil Procedure Code was yet again replaced by Section 89. And along with the second schedule, we all know that there were numerous powers to the court which was given to the court to refer to the matters to ADR mechanism. This showed that how even the CPC, the legislation formulated at that point of time, laid stress on the out of court settlement, and that was one of the effective legislation in that particular period. Thereafter, this Indian Arbitration Act of 1899 got replaced and we got Arbitration Act of 1940. Okay, now the Arbitration Act of 1940 was into picture, but even during that period, panchayats were very famous, and an effective mechanism to resolve the dispute in the villages were just panchayats. So I would say that time and again, during the urban and the rural culture, if you want to divide it, so during the rural culture, arbitration, the amicable dispute resolution mechanism, in the name of panchayats has already gained a toll, and people were using it. When it comes to the urban part, we were still struggling with the legislation, but we knew the importance of arbitration. We knew the importance that how it has evolved. So we tried our level best, and now today we can see that from 1940 we have the time traveled, and we have come across to 2021 act as well. Now, Arbitration Act 1940 came into picture. That was also one of the, I would say, a big stepping stone for the evolution of ADR in India. And there were a lot of pitfalls which came. There were a lot of disagreements which came with this particular act. But I would say that even after the disagreements, the lot which we study today into a structured format was the judicial rebuffs which were taken from the Arbitration Act of 1940. Okay, so it was considered as one of the most comprehensive and I would say the concrete piece of legislation which was enacted by taking into consideration the commercial sectors of that time. This act initially prevailed whole of India, Pakistan, Balochistan at that point of time, but was soon amended after the independence. Now, the law which was governing arbitration at that point of time was Arbitration Act of 1940, the Arbitration Protocol and Convention Act of 1937, the Foreign Arbitral Award Acts of 1961. Now, the first mentioned statute dealt with the domestic aspects of the arbitration, that is the Arbitration Act of 1940. The latter statute dealt with the recognition and enforcement of arbitral award when we have the international regime. However, there were I would say there were a lot of lack of clarity on various facets, and therefore, with the passage of time, we had numerous controversies which took place with that. For instance, the Act of 1940 was silent on the execution of foreign awards. Therefore, they only covered the domestic arbitration. The Act was not clear on the formation of arbitration agreement, which further again led to the failure in procedures. Then one of the I would say the most important and the major drawback with the Act persisted was with the validity of the award given by the arbitrators. Okay, because today also we talk about execution. So when you don't have anything which is respect to validity, why is people even going to trust you for that matter? Okay, so the act had the provision that the award needs to be approved by the court. This again opened a path of undesirable intervention of the judiciary. Now, we should be very clear about something called judicial intervention and judicial review. Judicial review is something which is very important, okay, which is done under the constitutional provision. But when it comes to intervention of the judiciary, this is unnecessary, making the process, I would say lengthy. I want to go for a private process. I want to go for arbitration. Now, if I'm not able to appoint my arbitrator, I have to go to the court. If I'm not able to give a proper arbitral award, I have to go to the court. If I have to set aside my arbitral award, I have to go to the court. Now, this is judicial intervention, which was in the 1940 Act. But at that point of time, we cannot blame even the legislatures, because they actually were trying to build up something which was not there from before. So they were trying to build up something from scratch according to the societal perspective. So, okay, different courts gave different ruling on the same subject matter, which led to the numerous complexities. The act was also silent in various other matters as well. For instance, like I mentioned, a lot of instances I gave, for instance, any arbitrator can resign even between the proceeding, which has led to the huge losses for the parties. It could cause unnecessary delay. Also, there were no recourse mentioned in case of the death of the arbitrator. I remember there was a very famous case of Guru Nanak Foundation versus Ratan Singh. I think it was a case of 1981, and it was observed at that time by Justice Desai that the way in which the proceedings under the Act are conducted, and without any exception challenged in the court, he has given a very famous quote, which is given in every book, has made the lawyers laugh and legal philosophers weep. Okay, and which actually opened the I would say the eyes of lot of legislative framework and everything. And thereupon we had the 76 Law Commission report on the Arbitration Act. Okay, and the Law Commission of India in 1978 recommended various modifications in the Arbitration Act of 1940. They covered various loopholes, and therefore it became the need of the hour to look into the same and take into consideration all the commercial realities and draft a new legislation accordingly. Now, that was with respect to the pre-independence part. Now, when we speak about the post-independence, because post-independence is also the part of evolution of ADR. Now, identically, the situation which prevailed pre-independence, I would say the same circumstances prevailed even in the post-independent period. The only difference which lied in the was with respect to the perspective of ADR. ADR was given more structurized format framework because of the growth of the society, increase in the commercial growth around the boundaries. In the year 1947, the Industrial Dispute Act was formulated, which also recognized various laws, rights, and liberties of the workmen working in various industries. This also led to the reorganization of the alternative dispute resolution concept, and it was very easy for the worker to resolve their dispute within themselves rather than going to the court. Also, when we talk about the cross-border transactions, they were also increasing because we know for a matter of fact, 1991, we had the LPG. So there were a lot of cross-border transactions which were increasing. So the disputes at that point of time also increased, and therefore it became the need of the hour again to formulate the ADR mechanism. And given a picture of international perspective, where people actually want to come and do trade with you, but if you have any issues, if you have any dispute, you have no mechanism to resolve it. So that actually made us look very bad, and therefore the United Nations Commission on International Trade Law, which we properly known as UNCITRAL model, produced the model law, okay, in the field of international commercial arbitration. In 1989, I would say there was a departmental advisory committee which was being recommended that there should be a new act which should be framed in accordance to the principles of both national and international perspective of ADR mechanism, and they should be acted and executed properly. The committee mostly emphasized on the use of relevant common principles, and obviously there was a very structurized language of ancestral model which we cannot use it as it is, but it was redrafted, it was recommended, and after a very long gap of these changes, they implemented the Arbitration and Conciliation Act of 1996. Now, in the post-independence period, the formulation of this Arbitration and Conciliation Act of 1996 can be considered as one of the major and commendable steps towards the upliftment of ADR mechanism, because it is giving different traditional approach of dispute resolution. This act gave a special recognition of conciliation as well, which is mentioned in the third part of the act. This new act brought about several changes by giving a statutory status to many concepts, along with an international touch to it. Then we also had Section 89 of the Civil Procedure Code of 1908, which gave an element of understanding between the parties who are in dispute if they want to opt and go for an alternative remedy. Now, as the act focused more towards the non-adversarial objective, it gradually started become one of the most specific combats to resolve dispute, along with applicability of law and enforcement. Why? Because obviously when we are talking about adversarial approach, there is a set of procedure which everyone had to follow. Okay, and when you are getting a window where you don't have to follow the structurized format, where you don't have to follow step A, B, C, D, when you don't have to go to that flow chart, definitely a majority of people will say that, okay, this is less complex for me. Let me go there and see how ADR works for me, which brought us or made us entered into a modern era, I would say a new phase of ADR. Okay, and the modern era, unlike the previous phase, actually showed us two big pictures when we discourse about the concept and utility of ADR. The first one was the developed structurized perception of ADR, which is an exceptional to the traditional method of dispute resolution, which can be easily opted by the parties by using its diversified techniques, and can help the Indian judiciary system to reduce the burden or the backlog of the cases, as it provides various methods of settlement, including arbitration, conciliation, mediation, negotiation, lok adalats, okay, mid-up process, ODR for that matter, online dispute resolution, which became very famous during the COVID time period. It can easily work as an alternative to the long-established litigation method adopted. However, if we talk about the other picture, which focuses more on the gray areas, which is less talked about, less opinionated about, and undoubtedly, we can say that ADR is a cost-effective, flexible process. But yet again, there are companies and other companies who yet being binding on their commercial nature, accepting this less adversarial approach they are not accepting the way it is, and they are opting for litigation. That means there are certain points to ponder, there are certain points to discuss, that we know that it is a new concept. Every phases of history has mentioned it, but we never had a structurized format. Today, when we are putting certain transformations, but still there are loopholes, there are certain things, we can see a more edified view of ADR today, which still persists now. But still, yet again, there are certain loopholes which are unlooked. Okay. Once the ICC tribunal issued an award, with respect to the international commercial arbitration, when they said that the Indian government lacks the effective measures of asserting different claims and enforcing the rights about the same. At that point of time, only we need to see that where are we lacking. And there are so many landmark cases which has come across, which still talks about that what are the different lacunas which are persisting in the with respect to time limit, with respect to interim application, with respect to foreign seats, with respect to exorbitant fees. Okay, why? Because these are the only important aspects where we are trying to opt for a private process, and we are not going for litigation for that matter. But when you have textured and when you have structurized, but still even after structurizing, you are not giving that kind of importance or that kind of utility to the structure which we actually need, then how are we even going to opt for ADR? Okay, so yet again, looking into all these perspectives, there were a lot of changes which were being brought across. There were 2015 amendment which brought about fast track arbitration. Then we also had a 2019 amendment. We also have 2021 amendment. All of these established the concept of arbitration council as well. They stated that we need to have an arbitration council. They gave more emphasis that how international commercial arbitration can develop in a different form. Okay, now apart from the Indian perspective, if we consider the concept of ADR for different countries as well, like, we always need to have a comparative study, because when we do a comparative study, we actually know that where do we stand. So we see that the evolution of ADR has a long way. Okay, it has come from, like I'm always telling, that sitting under the tree and resolving the dispute, to today sitting in the AC room with a particular format in my hand, that these are the different things which I'm supposed to do. I have an arbitrator appointed and who is in a suit listening to me, the subject matter expert. So yes, of course, we have come a long way through. But if we see the different nations, we can infer that this concept was even not new even then. However, many a times various criticisms were surrounded. There were a lot of misnomers which carried at that point of time also. Like for example, if we talk about the letter A in alternative dispute resolution, they used to say that instead of alternative, the word appropriate was more accountable. So we can see that there were small issues, criticisms which were coming, and when we try to pierce the veil of different countries, we can acknowledge that the ADR is nothing new, but we have a new faces and structure around the world. Like for instance, Bangladesh, they consider it as an old informal quasi judicial system, that's all. Okay, but today if we see the other countries, Hong Kong, we see Singapore, we see Paris, they all have established institutional arbitration centers. Today, even in India, we can say that we have institutional arbitration centers in Mumbai, Delhi, Hyderabad, which are working very properly. But yet again, there are a lot of things which we need to acknowledge and which we need to see. Like, if I remember, there was a judgment given in the US Supreme Court, and there were these lines which were being stated that the courts of the country should not be placed where the resolution of dispute begins. Actually, they should be the place where the disputes end after alternative method of resolving disputes have been considered and tried. Okay, so basically what they are trying to say that the courts and the places should not be a place where you are actually taking a rivalry on. It should be a place where you actually find some alternative solution, and you think positively that what could be the flexible approach and how we can change the society into the most affirmative form. Okay, there are a lot of cases also which has come across. Like for instance, there was one of the famous case of US versus Microsoft antitrust case, which involved mediation in efforts. Okay, around the time, at that time of in ancient city, there were a lot of ADR mechanisms which were being used time and again. So I would say that the concept of ADR is actually not a very new concept. The only thing what we discuss and we see today is that we consider it as the old chapter with a new cover. Okay. And when we talk about the evolution of ADR, yes, of course, we have evolved a lot. The legislature, framers, the framework, everything which we see today is giving a very positive vibe. It's giving a very positive perspective where we actually feel and we actually think that, okay, if we're having a dispute, let's try for arbitration. Let's try for mediation for that matter. Even the international regimes recognize negotiation. Okay, if we study international law, everywhere it has been stated that, yes, of course, let us try negotiation. Let us try and resolve our disputes through negotiation. So today, if we emphasize on the latest development, we can see that ADR is, investigated in all facets, and we are working upon the framework and legislation of all its types. And in order to, conclude my discussion today with respect to the evolution of ADR, I can also say that right from, solving the dispute under the tree, and today when we are resolving the disputes under a lot of legislations and mechanism, we have covered a long pathway. But yet again, with respect to the perspectives of ADR, we still have a long ladder to climb, which I feel that we all are doing. So with this note, I want to conclude this particular discussion with respect to the evolution of ADR mechanism in India. I think I've tried to cover, in a very short way, that how and where ADR was used during the ancient time and today where we have traveled. And yet, of course, there are a lot of things, there are a lot of examples which I can give, like when I'm talking about the Vedic period, or when I'm talking about the, I would say, the civilization part. We also have Hindu mythological history where we see that how arbitration was being used even by Lord Krishna. Okay. And there are a lot of different things which we can see. Apart from this, if we want to emphasize on the evolution of ADR, I would also say that the evolution of ADR can be seen in jurisprudence. It can be seen in constitution. It can be seen in, I would say, administrative law. So there are a lot of laws. Okay, I also mentioned about the Industrial Dispute Act, so obviously labor laws. So ADR has been used in every facet with different names. Okay, and yes, of course, we are still evolving in it, and I really believe that we are going to give a much more structurized format of ADR in the coming times. So yeah, with that, I want to end my discussion. If there are any questions or queries, I'm ready to take up that. Over to you, Aditya.
Thank you, ma'am, for that enlightening presentation. Your insights into the nuances of ADR from the national, international, and historical perspective have given us much to ponder. Now, before we wrap up tonight's session, we will address a few questions that were submitted by our audience beforehand. These questions have been carefully selected to enrich our discussion. So, ma'am, the first question is from the student's context, and it is very student specific. If someone wants to enter the ADR field, what are the relevant skills that are required that can be focused upon individually?
Okay. So yeah, a very student-centric question, which times again comes up to me also. So when you are trying to focus in the field of ADR, now I would like to say that ADR is just an umbrella. You have arbitration, you have mediation, you have conciliation, you have a lot of things which are being attached to it. And obviously, you can make your career in dispute resolution. It is a high climb ladder which you can take up. So first you need to have the knowledge of the subject. So when you're talking about your CV should speak that, yes, of course, you have worked in dispute resolution. Okay, so when I'm talking about that, your CV should speak, then in that way, for a law student, it is very important that you should have certain certification with respect to ADR. Okay, whether it's with respect to mediation, whether it's respect to arbitration, there are a lot of certifications recognized, institutions which are letting you know about it. Furthermore, you should have certain research papers on it. Okay. Now, when we are talking about how to make a career, then obviously there are firms. Even when we talk about the firms, I'm talking about the tier one firms to tier two firms to the boutique firms as well. They have a certain dispute resolution forum in their particular firms. So I would suggest the student can definitely, if they are in their fourth years, like, in their, the nascent years of their law career, they can definitely try for internship so that they can have the hands-on experience, the practical experience, that how they can take things forward with respect to that. Even for that matter, the court, okay, the court where who are actually felicitating arbitration, like for instance Delhi High Court, they need researchers, okay, who can research for them in that particular matter. So they provide a lot of internships. They can definitely go ahead with that. Then you also have arbitral institutions where you can definitely apply. So I would suggest that you can do some moot courts, you can do some certificate courses, you can do some internships where you get the practical application. And then to start with, definitely you can try out these kind of options.
Thank you, ma'am. The next question is on the very lines of your response that we need certifications, we need accreditations, etc. So the question is as follows: what does such terms like FCI, ARB, FAA, ARB, etc. means, and are these any accreditations or designations? If yes,
Aditya, I think I lost your voice. Can you just repeat the last line?
sure, ma'am. I'm really sorry for the connection issues. The question goes: what does such terms like FCI, ARB, FAA, ARB, etc. means? Are these any accreditations or designation? If yes, how to achieve them?
Okay, so I would say that, these are your, I would say they are the joint group of experienced dissolved resolution practitioners. Okay. And these are, the CIRB, the FCIRB. You should definitely be the part of it because, like I said, the Chartered Institute of Arbitrators or the FCIRB, if you are talking about, okay, they have the knowledge, detailed knowledge about the main procedural elements of an international or non-domestic arbitration, which can be used in the arbitration legislation, which are based on the ancestral model law. Okay, so definitely they counts a lot because that is trying to give you an hands-on experience, and you can definitely become the member of it because that gives you a kind of accreditation. Okay, that gives you a kind of accreditation that you, of course, you are the part of these kind of institutions where you actually are aware of that how you can take things forward. Even for that matter, I would say that there are a lot of courses which come across, and when you finish those certification courses, they even provide membership to these kind of accreditations. Okay, so I would definitely say that if you want to make your career in dispute resolution, you should definitely try and become the member of these these institutions, because that gives an hands-on experience to you, because you have a lot of people who are involved into it.
Thank you so much, ma'am. The next question comes from a participant who is interested in specialized arbitration, specifically maritime arbitration, and
Okay.
asks, could you
Okay.
elucidate the arbitration proceedings as well as the evolution and the future in maritime arbitration? Also, what are the current challenges that these specialized arbitrations face?
Okay, so maritime arbitration encompasses basically with your ship finances, construction, I would say sale, acquisition, deployment, carriage of commodities, okay, cargo transportation, and lot of other maritime, I would say, approach which is coming across. Now, maritime arbitration today is, as I told you, it is related to your sea vessels. Okay. So in today, you have a lot of scope with respect to maritime arbitration as well. I would say that in London, there are out numbers of commercial arbitration which comes with respect to maritime arbitration. And with respect to getting the knowledge with it, that how you can take things forward and how you can work on it, there are law colleges. To name few, there is Gujarat Law College, which keeps on doing maritime law courses, certificate courses, which actually let you know that how and where you can get yourself involved. Okay. And with respect to maritime, the most important challenge is that the openings or the perspective of maritime law arbitration in today's area is less, But at the same point of time, it is also a pro for you, because if you have the hands-on experience on that, so whenever there is any opening or anything of that sort, you can definitely opt for it. So the companies are also having maritime arbitrations for that matter. Even the government needs consultant for maritime arbitration. Okay, so the challenge and the opportunity, I would say, is the same. You have very less opening, but if you have the idea, if you have the hands-on experience on that, you can definitely change this issue into your, positive point.
Thank you so much, ma'am. The next question is on the lines that I picked up from the lecture. When
Okay.
you said that cyber law is continuous, the situation around cyber law, environment around cyber law has continuous evolution in the means as well as the ends. So, ma'am, how does the evolution in technology affect resolution ADR, the surrounding lands?
A lot. I would say a lot. I can give you two best example. Okay. ODR, online dispute resolution. Okay. Online dispute resolution is just a form of arbitration, but it is being done online. If we see the legislative framework, we don't have legislative framework. But if you check online, you have a lot of companies which has been established, like CADR, Presol 360, all these companies who are working in the field of ODR. Okay. ODR has helped a lot during the COVID times where you just cannot travel. You need a resolution for your dispute. Okay, so at that point of time, technology helped a lot. Okay, technology helped a lot. People were just sitting and they were following the procedure of ODR. But like I said, that there are two sides of the coin. There were people who never trusted this mechanism. But when you have to do a business and you have to take things forward, then obviously you have to trust that process, right? Because that becomes your necessity. So even people started trusting ODR. Then I would say blockchain technology. Blockchain technology in arbitration deals with the smart contracts. Okay, we still don't have laws for that. But the moment we start using it, it has been used with the help of Information Technology Act, IT Act, where we say that, yes, of course, we can recognize these kind of things. So when these smart contracts is being used, of course it is going to change the world. So what I'm trying to say here is that with the help of technology, when we are talking about ADR and when we are emphasizing on the fact that it can reduce the burden of the court, then obviously if we change ADR into a more technical forum, our dispute resolution and providing of justice system to the people is going to get a more speedy format. So of course, technology is very important, and I gave you the best two examples of ODR, the emphasis of ODR and the blockchain technology under the umbrella of alternative dispute resolution.
Thank you so much, ma'am. The final question pertains to seeking your opinion on the topic whether including or employing retired judges actively into the sector of ADR, is it beneficial or is it?
Aditya, again, I lost your voice, but I think I understood your question. Okay. So yes, retired.
Shall I repeat it,
Yeah,
ma'am?
retired judges. Now, again, I would not say I would say a straightforward answer. I cannot say a black and white answer to this, because these retired judges have experience, and arbitration, we say that we need people who are expertise in subject matter, but we need rigorous training. Now, now my understanding varies according to the people who are facing it, because there are people who are always open to learning. Okay, and they are always open to accept the technology. Now, there are pros and there are cons. The people who can listen to me is someone who themselves can decide that whether or not it could be a better port, or it could be something which we are playing with the mechanism of ADR. Okay, when we are talking about ADR, we need quick redressal. So we need someone who listen to us very carefully, who have the experience, and who tries to resolve our matter, who is open to technology, because we never know which process we are opting for. We can even go for ODR. So the particular person should be technological friendly as well. Okay. At the same point of time, we seek experience, because we don't want a new person to listen our dispute. Then there is no point in going for ADR. Okay. When we are talking about trainings, of course, there has to be rigorous training, because this is not a place where you have to use your laws. Like, for example, if you're going for mediation, you just cannot say laws. No, there you need to apply your logic. There you need to see what are the merits of the case. There you need to felicitate the dispute accordingly. So with a judge's mindset, you cannot run alternative dispute resolution concept. It is completely different. Although the procedural fact remains the same, where you're following the administrative law, the process of natural justice. Okay, but at the same point of time, you need to, there is a process. When I have done my PhD in arbitration, I gave a recommendation also that when we are talking about the appointed arbitrators, when we are talking about the schedules which are being mentioned, that who should be the arbitrator of a dispute, the person should not have a judge's brain, because it is a completely different concept. So rather than just saying judge's brain, I just want to say that the approach to that particular dispute should be different. I can give a very best example. SEBI follows online dispute resolution score. Okay, so if you have any problem with respect to your security market, you can definitely go and challenge, and you can make your point and score, and they are going to come back, they are going to freeze your account, and they're going to do different things which you cannot think about it. So when the people are going to approach, the person who is listening to me, I will have that kind of emphasize, or I will have that kind of knowledge that this person is technological expert, this person is ready to listen to me, and this person is not only talking on law but is also looking into the logic. So if this kind of setup is there, then why not judges and ADR? But if there is something which is different, then I would definitely say that there are a lot of scopes for appointment of arbitrators, conciliators, and mediators as well. So that would be my take on this particular question.
Thank you so much, ma'am. I cannot imagine any better response for this question. So thank you for providing such an insightful perspective on these complex issues. Unfortunately, that's all the time we have for the questions tonight. And with that, we conclude yet another illuminating session brought to you by Just Corpus. A big thank you to our guest speaker, Dr. Shivangi Sinha ma'am, for sharing her expertise with us tonight. And of course, a heartfelt thank you to our viewers for tuning in. I am Akshar Aditya, signing off for tonight.